Namaskar. I'm Dilip Singh, advocate. Welcome back to my channel Journey of Constitution of India. Now we are starting a new journey. This is part 1 of Article 15. The title of Article 15 is Prohibition of Discrimination. Please recall the words of Preamble at the start of this journey. Equality in status and opportunity. I think this is the Gangotri of the Ganga of right to equality and prohibition of discrimination as enshrined in Article 15. The name of this journey is Prohibition of Discrimination. Friends, please remember the name of the journey because it will continue in the next 2 videos. The question arises, prohibition of discrimination on what ground? There are 5 grounds given in this Article 15, that is religion, race, caste, sex and place of birth. So discrimination is prohibited on these 5 grounds only while we are dealing with Article 15. Article 14 enshrines the principle of equality and Article 15 mandates the absence of hostile discrimination, but it promotes compensatory discrimination in favor of disadvantaged sections of our society. But before we go on in this journey, seeing the various colors of this Article 15, let me ask you one question. Do you remember a film that came 1 year back starring Ayushman Khurana, and the name of the film was on certain article? Hope some of you might have seen that film also. The name of the film was Article 15. The founding father of our Constitution meticulously drafted the contents of Article 15 because they wanted to use it as a weapon to break the barriers of the caste system which were prevailing at that time, and that is even today deeply rooted in our society. Dr. Ambedkar fought this evil of caste discrimination throughout his life, so he was aware with the importance of this Article 15, where the purpose was to prohibit any kind of discrimination based on the basis of religion, race, caste, sex and place of birth. Now we will read the text of Article 15. Before that, let me tell you one thing. There are 6 clauses in this Article 15, but originally it were only 3 clauses in the Constitution. 3 clauses were added later on. The first clause in categorically terms says, the state shall not discriminate against any citizen on the ground only of religion, race, caste, sex, place of birth, or any of them. In this article, in this clause, there are 3 important concepts or 3 important points. First, this clause is a command against the state. Second, this right is available only to citizens. Third, the word only is placed before religion, race, caste, sex, or place of birth. This is of very significance because besides these 5 parameters and 5 grounds, the discrimination can be made on the basis of other available grounds. Now, I'll read the text of clause 2. That is a very important clause because that is directly strikes at the root of the caste system and prevailing at that time, where the lower caste were not allowed to use the public space. So the clause 2 says, no citizen on ground only on religion, race, caste, sex, place of birth, or any of them be subjected to any disability, liability, restriction, or condition with regard to, for subclause A, access to shops, public restaurant, hotels, place of public entertainment, or clause B, subclause B, the use of wells, tanks, bathing, ghats, roads, public or places of public resort maintained wholly or partly out of a state fund or dedicated to the use of general people. So there are two catches here. First is the access to public place, and second, use of public facilities by um, uh, public facilities maintained or funded by a state or dedicated for the public purpose. So this clause 2 is targeted clause. It has to hit at the root of the system which were prevailing in the society. The second clause is one important aspect. The second clause is command against state as well as the individual. So even if any individual is making any kind of problem or any kind of discrimination at the public place, so he is also to face the consequences of the law. Now the third clause comes. Third clause is basically a compensatory discrimination clause. Means the discrimination or disadvantage women and children are having in the society. So any law which can be made in favor of women and children. That's why this article, article 15 subclause 3, clause 3 is very simple and of very wide amplitude, because it starts with a non-obstante clause. Nothing in this article shall prevent the state from making any special provision for women and children. So these were the three original clauses incorporated in the original constitution. Now, the clause 4, which was inserted in the constitution by the very first amendment of the constitution. There is a background of this clause 4. A Supreme Court judgment, in a Supreme Court judgment in the case of the state of Madras versus Champak Durai Rajan, the Supreme Court had quashed or set aside a government order by which a reservation policy in job and educational institutions were ordered by the government of Madras Presidency and to be implemented in the government on private government institutions. And Supreme Court set aside, finding it discriminatory on the ground of caste particularly. So at that time, Pandit Nehru, whose government was there, decided to bring this addition in the Article 15 to counter and to come over the effect of that judgment. So clause 4 says nothing in this article or clause 2 of Article 29 shall prevent the state from making any special provision for advancement of the socially and educationally backward classes of citizens or scheduled caste or the scheduled tribe. So this clause was brought for a special purpose of making provisions for advancement of three categories of people. First, backward class, educationally as well as socially. Second, scheduled caste, and third, scheduled tribe. This fourth clause was added, as I told you, by the first amendment of Constitution in 1951. Now, there is one more thing which I would like to add, that while the debate was going on, Article 15, Clause 3, even at that time, a group of members of the Constituent Assembly demanded that a similar provision be included in the Constitution, but Constituent Assembly decided that this should be left to the wisdom of the coming Parliament, and it will be. And so, by the very first amendment, the Parliament thought it necessary to bring this kind of arrangement in the Constitution. Now, the next is Clause 5. It also starts with non-obstante clause, and it starts that nothing in this article or in subclause G of clause 1 of article 19 shall prevent the state from making any special provision by law for advancement of any social and educationally backward classes or citizens of, or the other special provisions related to the admission of to educational institutions, including private educational institutions, whether added or unadded by the state, other than the minority educational institutions referred in clause 1 of article 30. So this clause 5 was inserted by the amendment, by the 93rd amendment in 2005. Here again, the background of this amendment was a judgment of Supreme Court in case of P.A. Inamdar versus State of Maharashtra, decided on 21st of August 2005, where the policy of reservation vis-a-vis the private institution was denied by the judgment of Supreme Court. So I'll deal this entire judgments, the first I mentioned, or this Inamdar judgment, in detail in my next video. In this video, we will be concentrating ourselves only to understand the basics of the article and the background of the articles. Thereafter, the sixth clause was added. This is the latest addition in the sixth, in the Article 15, which was brought into Constitution by 103rd Amendment in 2019. This is the latest one, and this was created for the purpose of providing reservation to economically weaker sections of the citizens. And this clause is inserted in the as to counter the restrictions of Article 15, Article 19(1) subclause G, and Article 29(2). So this was added by the current Modi government, which was long promised, and interestingly, it was supported by all political parties. Clause 6 has two subclauses. Clause A and Clause B. Subclause A and Subclause B. Subclause A is specifically for economically weaker sections other than mentioned in Clause 4 and Clause 5. So Clause 6A stands for, or describes about that its applicability is other than Clause 4 and 5 categories people. Then the next comes the subclause B of Clause 6. This is for admission to public and private institutes other than which are mentioned in Article 30, Article 30 Clause 1. In addition to the existing reservation up to 10% of the total seats. So these are the criteria of that. So in this case, it was Clause 6 was inserted only for economically weaker section up to 10% of the reservation of 10% reservation of the total seats, and it is also applicable in private as well as public or government institutes. Important point is that this clause 4, 5, 6 are non-obstante clause, means it is applicable besides the provisions of the other provisions of the Constitution. Here, in particularly in this three clauses, we find that Article 19(1)G is specifically mentioned, which is freedom to practice any profession, carry out any occupation, trade or business. The other is mentioned is Article 29, which is for cultural and educational rights of minorities, linguistic minorities, as well as and Article 29(2) is non-discrimination in admission on the ground of religion, race, caste, language, or any of them. The other article which is mentioned in these clauses is Article 30 subclause, so Article 30 Clause 1, which is the provision for minorities whether based on religion or language, and their right to establish administration, educational institutes of their choices. So these three provisions which are frequently mentioned I have described here. One important aspect of this article is that, which is always to be kept in mind, that this article 15, that this deals only with these 5 grounds. So if there is any other ground available for discrimination or for making a class legislation, then that is permissible here. Like some jobs, some study, something which are suitable only for female, as the job of nurse or air hostess. So this kind of discrimination can be made on this sex basis. Recently, Article 15 were in news in 3 judgments, and these judgments were: first, National Legal Services Authority versus Union of India in 2015. It was a division bench of Supreme Court for the right of transgender, where this Article 15 is dealt in detail, and on the basis of the discrimination on the basis of Article 15, these provisions, this right to transgenders were ascertained, and they are. The second judgment was Justice Puttaswamy's judgment, which was of I dealt in my previous video, which were of 2017, where the right to privacy was decided. Even in that judgment, Article 15 was dealt in detail. And the other judgment which came in 2018, that is Navtej Singh Johar versus Union of India. Even in that judgment, Article 15 is dealt in very detail. So I have dealt these judgments in my previous videos. So in recent past, we saw that this Article 15 was frequently resorted to decide the right to privacy or right to sexual orientation. And so this Article 15, this is the basic concepts of Article 15. Thank you very much for watching this video. In this video, I deliberately did not deal with judicial pronouncements, because that I will deal in the next video. Please subscribe my channel so that the video can reach to you in time. Thank you very much. Namaskar.